I'm going to talk about a fundamental change that took place in American legal thought in the late 19th, the late 19th and early 20th centuries. Before the change, natural law played an important role in our legal system. Lawyers believed that human affairs were governed in significant part by laws of nature, laws that could be discovered in much the same way as the natural laws governing the non-human realm, which we call scientific laws today. These laws were understood to have an existence independent of human volition. That is, they were not human creations. So here's an example. The law forbidding murder was understood to be a natural principle that regulated the behavior of human beings. It was a law that we found, not one that we made. To be sure, nations might enact legislation forbidding murder, but American lawyers before 1870 or so would have said with virtual unanimity that murder would still be illegal even in a nation that had not enacted any legislation prohibiting it. It would be illegal because murder was contrary to the law of nature. So the law forbidding murder was like the law of gravity or the laws of optics. It was a law that existed in nature, waiting to be discovered, not made by humans. Now, this understanding of law almost completely disappeared in the late 19th and early 20th centuries. After the change, lawyers believed, and they still do, that natural law plays no role in our legal system. So today, lawyers obviously still consider murder to be wrong, and they would deplore as grossly deficient the legal system of any nation that failed to prohibit murder, but they would say that in such a nation, murder is just not illegal. Or to put it another way, in 1850 or so, when a lawyer spoke in court, it would not have been unusual for the lawyer to discuss the law of nature along with statutes and court decisions as ordinary sources of law. Right? Today, of course, it's the opposite. If a lawyer goes to court today and says, well, Your Honor, yes, we've got some statutes, we've got some cases, but first, before we get to them, I'm going to talk about the law of nature. Right? The judge is going to look puzzled. Opposing counsel is going to start planning the victory party because natural law is just no longer part of a lawyer's toolkit. Now, before we go any further, I want to clarify that the term natural law, it meant something different in the 18th and 19th centuries from what it means today. So the term has two main senses today, but neither of them captures what it meant back when natural law was part of the legal system. Okay, first, many people today think of natural law as a set of Christian doctrines with origins in the Bible. And so natural law in this sense tends to yield conservative outcomes, such as the unlawfulness of abortion or same-sex marriage. And for this reason, today natural law is often viewed with favor on some parts of the right and with suspicion on the left. But there was nothing conservative about the natural law practiced by lawyers in the 18th and 19th centuries. Natural law had no political valence one way or the other. It was just one more source of law, like statutes or court decisions, that all lawyers employed. And in fact, most of the time, there wasn't even anything particularly religious about the natural law of the 18th and 19th centuries. It rested at bottom, it rested on a Christian foundation, but lawyers didn't believe that the Bible offered answers to most of the litigated questions that arose in a complex society like that of the United States. To the extent that religious belief was involved in the elaboration of natural law, it was usually nothing more than the belief that God had created humans with a power of reason that enabled them to work out the answers to difficult legal questions. So the version of natural law advanced by its religious proponents today scarcely resembles the natural law that was used by the lawyers of the 18th and 19th centuries. The other widely held conception of natural law today is held by philosophers and philosophically minded law professors. On this view, natural law means a view of law in which what the law is depends, at least in part, on what it ought to be. And it's conventionally contrasted with positivism, the view that what the law is and what the law ought to be are two separate questions. Now, this is an understanding of natural law that only arose in the mid-20th century. It does capture one feature of natural law as it was understood by the lawyers of the 18th and 19th centuries, but it lacks several of the other features that they would have considered essential to natural law. For much the same reason, 19th century lawyers didn't distinguish between natural law and natural rights, as some philosophers of law do today. Rather, 19th century lawyers would simply have said that a natural right is a right protected by natural law, as distinct from a right protected by some other kind of law, like a statute or a constitutional provision. So in thinking about natural law in the legal system in the 18th and 19th centuries, we have to be careful that the present day definitions of the term don't leak back into our thinking, right? Because back then when lawyers talked about natural law, they meant law that was found in nature, right? As distinct from law created by human beings. It was very much like the way we think of scientific laws today, right? We didn't enact the law of gravity. It was there in nature, waiting for us to find it. When lawyers stopped using natural law in litigation, that was a big change because it made lawyers think differently about what judges do when they decide cases. Today, when there's a case that existing law doesn't easily resolve, we think of the judge as making law to fill in the gap. But when natural law provided a reservoir of principles for judges to draw upon in deciding hard cases, the process of judging looked very different. Lawyers thought of judges as finding the law, not making it, right? And so today, when we read old court opinions or old treatises, and a judge or a lawyer says, oh, judges always find the law even in situations that have never arisen before, we're likely to wonder, how could they have been so naive or so obtuse as not to see that judges are really making law? But that's because today we think of the legal system as consisting only of law made by humans. Our conception of the legal system only became standard in the late 19th century. Before that, nature was also an accepted source of law, and it allowed judges to find principles even in completely new factual situations. Okay, so how did this work? It was understood that there were two kinds of law. There was positive law, the law made by humans, and there was natural law, the law not made by humans, but found in nature. Natural law was based on the nature of human beings. Just as all other objects in nature were governed by natural laws, humans are in part of nature. Humans are governed by natural laws too. Positive law could be different in different jurisdictions and even in the same jurisdiction at different times, but natural law was the same everywhere and at all times because human nature didn't change. How is natural law to be discerned? Well, sometimes by revelation, every once in a while, some basic principles could be found in the Bible, but mostly just by using the power of reason. People were understood to have an innate sense of justice, an innate sense of right and wrong that helped them to identify what was fair, what was right, what was reasonable, what was best for all concerned. The process of discerning natural law was often indistinguishable from the process of working out which rule would be the most reasonable or the most sensible. It's basically what we today call policy reasoning. At the time, it was called identifying principles of natural law, but if we drop the labels and just look at the substance, it was pretty much the same thing. Now, there was a complex relationship between natural law and positive law. It was often said that human law was void if contrary to natural law. Now, that may sound like the relationship between statutes and constitutional provisions, and American courts did sometimes refuse to enforce statutes that they found contrary to natural law. But natural law was used much more often to interpret statutes than to strike them down. And that's because many statutes were understood as legislative efforts to restate or to enforce natural law. And so courts were far more likely to use natural law as a guide to what the legislature meant than as a measuring stick for determining the statute's validity. Of course, not all statutes were understood as declarations of pre-existing natural law. Lawyers often spoke of natural law as governing only the most fundamental aspects of life, leaving legislatures free to fill in the details. So, for example, whether there should be tariffs on imported goods. That was a question that natural law just didn't speak to. Natural law neither required nor prohibited tariffs, so humans were free to make whatever positive law they wanted, which is another reason why judges rarely found legislation inconsistent with natural law, because if a statute governed an area in which natural law had no reign, there could be no inconsistency between positive law and natural law. Judges also often used natural law to fill in the gaps left unregulated by the positive law. When there was no positive law that was helpful, judges would resort to natural law. There's lots of cases like this in the 19th century. One that's still famous today is Pearson v. Post, the fox hunting case that's still in many property case books. One hunter chases a fox with hounds, the other hunter kills the fox. Okay, which hunter gets the fox? New York had no positive law to govern that situation. So the lawyers on both sides made arguments based on natural law. So did the judges who decided the case. And that's one reason why students today find the case so confusing. So 19th century lawyers thought human affairs were governed by the same kind of natural laws that we still think govern the non-human realm. So I'll give you just one example. Henry St. George Tucker was a law professor at the University of Virginia in the first half of the 19th century. He began his introductory lecture to his law students. He began by discussing the natural laws governing the crystallization of chemicals. Then he turned to the natural laws governing the growth of sunflowers, then to the law of gravity. And only then did he begin talking about the laws governing human affairs. As he explained, if there be a law for all created things, why not for man? Right? And if you think about it, for a person alive in, say, 1800, the preceding 2 centuries had seen an enormous growth in the stock of human knowledge. Physical processes like electricity or the movement of the planets, things that had once been poorly understood, were now understood to be governed by natural laws. And people were optimistic that we were on the verge of similar discoveries regarding the natural laws that govern human affairs. Now, to modern sensibilities, there seems to be one really obvious difference between the natural laws that were said to govern the human realm and the natural laws that governing the non-human realm. In the non-human realm, natural laws are empirical regularities, while in the human realm, natural laws are normative injunctions. So here's an example of what I mean. The law of gravity is that apples always do fall at a particular rate, not that they should fall at a particular rate, right? By contrast, in the human realm, the law prohibiting murder is that people should avoid killing others, not that they always do avoid killing others, right? So today, this distinction between empirical natural laws and normative human laws, it may seem like an insuperable obstacle to accepting the view that the laws governing human affairs are usefully understood as similar to the laws governing the non-human world. At the time, though, lawyers didn't make such a sharp distinction between the empirical and the normative. There was a long tradition of treating nature not just as a source of information, but as a guide to what ought to be done. And there was also a long tradition of understanding what we call scientific laws, natural laws in the non-human realm, as the commands of God, just like natural laws in the human realm. And so in the late 18th century and the early 19th century, it was plausible to believe that natural law governed human affairs much as it governed the non-human world. If we knew more about the natural laws of physics, say, than we knew about the natural laws of crime or contracts. Well, that just said more about the meager state of our own knowledge than about what it said about nature. Now, in the late 19th century, lawyers began to stop thinking this way. Natural law dropped out of the legal system. Now, why is that? Well, before I started writing this book, I expected that it would be because lawyers just stopped believing in natural law. They started thinking of it as superstition. But now I don't think that was the main cause. I think the primary change was not in how lawyers thought about natural law, but in how they thought about the legal system. Right now, some lawyers, I think, did indeed reject the concept of natural law in all domains of life, but most seem to have made a smaller move. That is, they came to conceive of natural law as a matter of personal conscience rather than a tool to be used in litigation. That is, they still believed, or at least recognized the possibility that natural law existed, but they just came to think that the courtroom was not an appropriate venue for discussing it. One could invoke natural law in a political debate, in a religious congregation, in a discussion among friends, but in court, human-made sources of law were the lawyer's only proper tools. So why did lawyers start thinking it was not appropriate to use natural law in litigation? I don't think there's any simple answer to this question. Rather, I think several things happened in the 19th century that contributed to this change. And I'm gonna emphasize four of them very, very briefly. Okay, one cause of the change, I think, was the adoption of written constitutions. We inherited our use of natural law from the English and to some extent continental European legal systems, but written constitutions were an American innovation. Right? Natural law had long been understood as a constraint on legislation, but of course, written constitutions served the same function, which raised the question whether American courts could have the authority to invalidate legislation that conflicted with natural principles, but not with written constitutional text. There was a big debate about that all through the 19th century, never got resolved. But in the course of this debate, American lawyers voiced the first sustained critiques of the use of natural law in litigation. So I think we can say that the adoption of written constitutions in the late 18th century laid the groundwork for the disappearance of natural law from the legal system a century later. A second cause of the change was the gradual separation between the spheres of law and religion during the 19th century. In the early republic, there was a big overlap between law and religion. Religion played a big role in public and governmental life. But that changed over the 19th century. Americans might not have gotten any less religious, but they gradually came to think of religion as a domain, as an aspect of private personal life, separate from public governmental life, separate from law. And so as law and religion gradually separated over the course of the 19th century, the notion that natural law should play a role in the legal system came to seem more and more anomalous. A third cause of the change was something much more practical, the enormous growth of case reporting that took place in the 19th century. In the early 19th century, published cases were really scarce. Lawyers necessarily had to ground their arguments on broad principles, including natural principles. But over the course of the 19th century, there's this explosion in case reporting. Lawyers they start complaining they're drowning in this sea of published opinions. And so the nature of law practice changes. Lawyers begin to rely more and more on specific precedents and less on broad principles, including natural principles. And then fourth and finally, there were several divisive issues in the 19th century in which arguments based on natural law were very prominent on both sides. For example, capital punishment, the role of women, and slavery. And these were, of course, highly salient political debates, but they were also issues that frequently arose in litigation, and participants in both sides of these cases framed their arguments based on natural law. And by the later part of the 19th century, there's just a lot of frustration voiced on the part of judges and lawyers, people beginning to wonder whether natural law is just too indeterminate to be used in court, because it could seemingly be used to support either side of so many questions. So each of these developments played a part in weakening lawyers' belief that natural law should play a role in the legal system. And eventually lawyers just stopped using natural law. And then obviously that didn't happen suddenly. It was a very gradual process that lasted a few decades. But by the early 20th century, the consensus is among lawyers and judges, the consensus is that arguments based on natural law just have no place in litigation. Law made by humans is all that courts can properly consider. Now, natural law still lives on in other walks of life. It's still discussed in philosophical circles. It's still part of our political discourse, but it's no longer an explicit part of the working legal system. And I'll give you one good example of the profession's rejection of natural law. Took place in 1991 during the confirmation hearings of Clarence Thomas, the first round of confirmation hearings. As a lawyer, Thomas had written articles and given speeches urging a revival of the use of natural law in litigation. That was an unusual position for the time, especially for someone who was a government official. And during his confirmation hearings, he faced a lot of hostile questions from the Judiciary Committee about whether he supported the use of natural law in litigation. And Clarence Thomas, he walked it back. He very prudently promised the senators that if he were confirmed as a justice, he would never use natural law to decide cases, and then he's been true to his word. But there are still some echoes of natural law in our legal system. American lawyers and judges, they no longer explicitly rely on natural law by name. But in some respects, they still make arguments that are reminiscent of natural law because of the position that natural law once occupied in American law practice. So one good example is the concept of human rights. Right? Human rights are often understood as rights that exist simply by virtue of being human, even when they're not conferred by, or indeed are contrary to, the law of the jurisdiction in which a person lives, right? So in human rights, they need not be grounded on natural law. They can be founded on international agreements and customary practices. But the very idea of a human right, as distinct from a treaty-based right or a customary right, carries a strong flavor of natural law. Another example can be found in the constitutional protection for property rights. Property was once understood as a paradigmatic natural right, something that was not created by law, but that was found in nature, that preceded law. When lawyers stopped using natural law, it created a puzzle, because if property was entirely defined by positive law, how could any particular positive law infringe the right of property, right? Your property was just whatever your positive law said it was. If you're familiar with the Supreme Court's takings clause cases, you'll recognize this dilemma. Another example can be found in the canons of construction that courts use to interpret statutes. Where do these canons come from? Right? Today we say, well, they come from old court opinions, but where did the judges who wrote those opinions find them? Right? Well, in the past, what we now call canons of construction were called principles of natural law, right? They're still around, right? We just don't call them natural law anymore. And I'll finish up with just one last example of the lingering influence of natural law. And this, I think, may be the most far-reaching kind of fundamental example. Natural law is still present in the voice that judges and lawyers use in their professional lives. So when judges are writing opinions or when lawyers are making arguments, they speak as if judges find the law, while in their heart they know that judges make the law, right? During the daytime when they're speaking in their official discourse, they speak as if judges find the law, but if you could get them at the bar after hours, they would admit that judges make the law, right? This is an aspect of lawyers' daily lives that's familiar, but if you stop and think about it, it's very strange. And the difference between what lawyers say and what they believe is a holdover from an era in which lawyers really did believe that judges find the law, right? They would gradually stop believing this, but the official discourse of the legal system never changed to match. Thanks very much.
Thank you, Professor Banner, for that excellent overview of your book. I will turn it over shortly to my colleague, Professor Dempsey, but before doing so, I will remind you again to put any questions in the Q&A box on the bottom toward the right. And our first CLE word, in tribute to Professor Banner coming to us from UCLA, our first CLE word is California. California is our first CLE word, California. And with that, Professor Dempsey.
Thank you, Professor Moreland and Melanie Dudley, for organizing this event, and to the McCullen Center for creating a context in which to have these kinds of conversations about the law, and for Professor Pojanowski for joining this conversation, and especially to Professor Banner for writing such a tremendous book. I have 3 brief comments, but first let me say how delightfully engaging I found this book. I'm not a legal historian, and so I feared I might have been out of my depth a bit in this book, but Professor Banner's style of writing is so clear, concise, fast-paced, intriguing. I mean, it's highly recommended to everyone, particularly students. So let me get into my comments then. So the first comment concerns what Professor Banner calls the two-sidedness of natural law. The basic idea here is that natural law arguments can be used on both sides of controversial issues, as he just discussed, so it doesn't really help us do that much to resolve any of these vexing political issues. And as he said, the examples he discusses include the death penalty, property rights, women's rights, as well as slavery and racial segregation. So I agree entirely with the thesis that natural law arguments can and have been used on both sides of these issues. And I appreciated Professor Banner's explanation of how that dynamic contributed to the downfall of natural law in the American legal system. But I want to pick up on something that Professor Banner returns to a few times in the book. And I'm just going to quote him at length here from page 3. He writes, "Today, natural law is often viewed with favor on the right and with suspicion on the left. But there was nothing conservative," he says, "about natural law practiced by the lawyers of the 18th and 19th centuries. Natural law had no political valence one way or another. It was just one more source of law, like statutes or court decisions, that all lawyers employed." And then later, page 180, he writes, "When natural law was a conventional part of the legal system, it had no political slant. It wasn't until the late 19th century there was nothing conservative about natural law." Okay, so granting all of that is true as a descriptive matter, I suggest there's something else we should observe, though. Politically conservative natural law arguments were much more likely to prevail against positive law. For example, natural law arguments protecting private property interests were likely to prevail against positive laws threatening to limit those interests. Whereas conversely, politically progressive natural law arguments were much more likely to be brushed aside and had relatively little weight against positive law. So, for example, with respect to slavery and the death penalty, particularly with respect to slavery, Professor Banner notes that Northern judges, quote, "retreated into slavery-specific positivism by rejecting the relevance of natural law in slavery cases." So I guess my question for Professor Banner is this: if it's true that there was nothing conservative about the natural law practiced by the lawyers of the 18th and 19th century, then why was it that in practice, it was only the conservative natural law arguments that prevailed against positive law? So that's my first point. My second one concerns what he just mentioned at the end, and I'll try to make this brief. It concerns me regarding the way we conceptualize what judges do and what they should do. and the ethically compromised role that we as law professors might play when we teach students to think like lawyers. So the basic problem is this: the American legal system is deeply disingenuous about what lawyers do and what they should do. So first, with respect to whether judges find the law or whether they make the law, as Professor Banner just discussed, there's this sort of two-faced view of it, right? So there's a great quote from Scalia that pops up a couple times in the book about he's not so naive as to think that judges merely find the law. He knows what's up, but he knows that judges make the law, but they make it as judges do, which is to say, as though they were finding it. So that's one degree of disingenuity. The second concerns what judges should do when it comes to natural law. And this harkens back to what Professor Banner just said about the Clarence Thomas confirmation hearings. And it's not just Thomas. We've seen this play out a number of different times. There's also so as that I'm not beating up on the conservatives, there's also a quite vexing explanation of what happened with Justice Kagan's own confirmation hearings, where basically the confirmation hearing is theater, and they need to go in and say the right thing and pretend as if they're just calling balls and strikes and not actually making the law in any way, despite the fact that they do believe that they're making the law. And particularly with respect to Thomas, it was clear that he did believe that natural law was an appropriate thing for judges to take into account. But it wasn't just that he promised not to do it on the bench. It was that he claimed that he didn't think that was an appropriate thing for judges to do. And so I think Professor Banner is right when he questions in the book whether Justice Thomas was accurately reporting his past views when he testified under oath at his confirmation hearing. Was he being accurate and honest about his views, or was he merely saying what he needed to say to get confirmed nowadays, and prudently disclaiming any practical interest in the natural law, which is how Professor Banner puts it. But I would suggest to all of us that this is hardly just a prudential matter, particularly when one is testifying under oath. I think all of these episodes, and the Kagan episode as well, where she claimed to have no view of what natural rights were independent of Constitution, which either is more disingenuity for the theater of confirmation hearings or a sign of a shocking lack of imagination. So I'm not just beating up on the conservatives. And I think all of us should be concerned about our profession's two-faced approach to these issues, whether it's ethically defensible, and in particular, as law professors, the extent to which we may be complicit in promoting it. Briefly, if I have, let me see, Michael, do I have time for a third point here?
Sure.
Okay.
Sure. Yeah, go ahead.
So my final point concerns a thesis that's defended by legal positivists, which claims that there's no single correct answer in at least some cases. Cases what Dworkin called hard cases, what HLA Hart called penumbral cases. And it's often supposed that this thesis is identical with another thesis, which is that there are legal gaps in such cases, which must be filled by extra legal sources. But that doesn't necessarily have to be the right picture of how things work. Instead, there might be a set of broad abstract principles in some, or perhaps indeed in all, legal systems, which are permissive norms rather than mandatory norms. And these principles might even be unarticulated, so not part of the black letter law, but nonetheless norms that are relied upon and engaged with by actors, legal actors and judges in deciding cases, and thus are source-based law, that is, they are part of the positive law. If these broad abstract principles are permissive norms, which are part of the positive law, then we can have penumbral cases, these hard cases, with no single correct legal answer, and yet we would still have no gaps in the positive law. And if that's the case, then judges are not making law in the sense of legislating from the bench. They're simply exercising their judgment in selecting from amongst a range of permissible norms to decide cases. That is, they're exercising what Ronald Dworkin called weak discretion. So, 9 days out of 10, I tend toward legal realism. So I don't know that I have a horse in this race, but on my less legal realist days, this picture of what judges do strikes me as an accurate account of what might be going on. such that judges are not finding law in the sense of finding a single correct legal answer in cases, but so too they're not making law in the sense of reaching beyond posited law to decide cases. And I should note that this picture that I've just sketched is one that was offered by Professor John Gardner, the recently deceased former professor of jurisprudence at Oxford, in a short essay on permissive sources and gaps published in the Oxford Journal of Legal Studies in 1988. And Gardner himself was both an ardent defender of legal positivism and, at least in some sense, a natural lawyer. And if this picture that he sketched is plausible, then maybe we're wrong to think about natural law and positive law as being in tension with one another. Thank you.
Thank you very much, Professor Dempsey. We'll turn it over to Professor Pojanowski.
Thank you, Michael, and thank you, Michelle, for your comments, and thank you, Stuart, for a wonderful book, and for everyone being here today. It's wonderful to be here to discuss Professor Banner's book, which was again a great pleasure to read. I'm not an historian, legal or otherwise, so I'm not really qualified to object, amend, or otherwise quibble with the evidence he's adduced for his argument. Yet one of the pleasures of the book is that one doesn't have to be a legal historian to find it rewarding, thought-provoking, and engaging. For example, there's a long-running debate among scholars of statutory interpretation about the extent to which courts, especially federal courts, use concepts like the equity of the statute to depart from plain meaning. The examples Professor Banner gives of courts in the early republic squinting at statutes to avoid contradiction with the natural law gives food for thought to textualists who argue that the separation of powers concerns pointed towards formalist interpretation and away from looser common law methods at the founding. An intellectual historian or comparative theologian, moreover, would find much to chew on in Professor Banner's argument that the privatization of Christianity in the 19th century contributed to the demise of natural law in court. The path to such privatization, of course, is easier when one believes that revelation is essentially private rather than institutional, and that the measure of natural law is revelation alone, as opposed to reason and dialogue with faith that forms its foundations. In other words, one suspects that the decline of natural law in the United States may be wrapped up with a certain kind of Protestant understanding of Christianity and the moral life. Now, this is not to say that a Catholic culture is immune from such a declension. Perusal of contemporary Spanish, French, and Italian law and politics will quickly dispel that notion. That said, this dimension may shed light on natural law's particular path of decline in the United States, as well as the failure of Catholic intellectuals to revive the tradition in a sustainable fashion, even when Hitler starkly posed the need for an objective moral law back during World War II. Now, but what struck me most about this book, however, is the strange kind of decline that we see. The title and its subtitle, which emphasizes why lawyers stopped using natural law, suggests that the practice is a dead letter, that we're all positivists now. But that's not the story Banner tells. Rather, he speaks of a death of the direct invocation of natural law and the rebirth of echoes of natural law or natural law substitutes. And I'm not talking here just about Lon Fuller's procedural natural law, which resists engaging in substantive argument directly, but rather more direct cognates to this kind of prelapse area natural law. Professor Banner argues that, as he said before, we apply canons of construction with asking where they came from, and while ignoring the legal realist jibes about their indeterminacy. As Professor Banner notes, courts default to general law, often as if Erie versus Tompkins never happened. Takings law seems to presume a natural right of property. The presumption against retroactivity assumes norms of fairness. And the practice of interpolating intention requirements into criminal statutes presupposes the moral requirement that agency is required for punishment. We can take this even further. Ronald Dworkin's ideal type of interpreter is Hercules, a judge with an encyclopedic knowledge of legal doctrine, moral and political philosophy, and the time and acuity to render the law coherent in its best light with respect to every legal question. Even hard-headed textualists and originalists hypothesize a reasonable reader of legal English that provides authoritative interpretation by identifying the most plausible public meaning of a contested text, thus providing us authoritative settlement. There's a sense in which we're all still seeking oracles who can identify objective law, after all. Of course, notwithstanding these echoes of a declaratory theory grounded in an objective authority outside ourselves, Professor Banner argues that where natural lawyers used to find the law, courts today understand themselves to make the law based on policy considerations. It's unclear whether Professor Banner sees this as a mere shift in terminology or as a transformation. I think he might be suggesting the latter. An echo or a substitute is not the original article. That said, the classical natural law tradition going back to at least Aquinas smudges the lines between these two approaches. I realize I'm hosted at an Augustinian institution here, so I'll proceed with care with my Thomism. So Aquinas argues that human law participates in the natural law in two ways. First, there's derivation, where the natural law more or less dictates what human law requires. Laws against murder, as Professor Banner mentioned earlier, come to mind here. Second, there is determination, instances in which the natural law is indifferent as to a particular decision, except for the fact that there needs to be an authoritative choice within the range of reason. Speed limits and which side of the road we drive on here are classical examples. Now, the distinction is not sharp. Even derived laws like murder are in part determination. Think about all the discretionary choices involved in drafting a murder statute. And determined laws are inspired by and seek to implement more enduring norms. We don't use random number generators to determine precisely how much benzene is safe in a workplace. We think about safety and human flourishing and things like that. So all human law is a composite of these two types of participation in the natural law. As Professor Moreland and I have argued elsewhere, the natural law requires human law to have something like tort law, though it may underdetermine, say, the choice between a single or a double intent standard for battery, or the appropriateness of strict liability in certain domains. So it can be true that there is a sense in which jurists can both find the law, derivation, and make the law, determination. And in any sophisticated legal system that's reasonably just, most of the work of a jurist will consist of following the rules laid down by determination, or by incrementally amending, improving, or rendering them more coherent within the existing system when the system permits them to do so. These latter incremental adjustments will appeal to the natural law, and when they require judgment, will resemble something like legislation, or Dworkin might say, a chain novel. Like the magma under a volcano, natural law will be the deep substratum of the positive law edifice, whose substance is the crystallized participate of previous appearances of institutionalized moral reasoning. And a reasonably just system will be like a shield volcano, which grows interstitially through incremental pulses of magma, not revolutionary explosions that reconfigure the landscape in one stroke. So has Professor Banner understated the decline? Is natural law hidden in plain sight today? Maybe, but I think we could also be right to wonder whether something's lost in translation here. First, there's the question of conflating natural law with moral realism, the belief that morality is objective and true and independent of what we think about it. If natural law consists in believing that there's an objective standard that judges positive law and should inform its content, then we can include Kantians, utilitarians, and pretty much any non-skeptical moral theory as a natural law theory. And maybe that's the best reading of the tradition, and it's certainly one I use to lead my students to think that natural law is at least a plausible thesis. But I'm starting to wonder whether that misses something. As Jeremy Waldron asked in an essay a while back, we want to know what natural law is like. And it's plausible to think that it has some of the features that we think of when we think of, well, law. Not just a measure of reason, but also authority with the care of the community, promulgation, and perhaps even sanction. I'm not sure if Waldron's right about this, and he wrote that essay as a critique of John Finnis, and I want to do my homework before joining in his dissent. But if that's the case, this metaphysically more elaborate and particular form of natural law would be a form of moral realism more likely to be dissonant with contemporary sensibilities. So perhaps in that sense, there has been a decline of natural law. On the other hand, to the extent that the understanding of natural law in the late 18th century was closer to rationalism, like Lieber's rights deduced from the nature of man, or the common sense philosophy of the Scottish Enlightenment embodied by the practical common lawyers, what we see today may not be so much an echo or a substitute for natural law, but the outworking of a tendency that was present at the creation of the American Republic. Thanks.
Thank you very much, Professor Pojanowski. So we are mindful of ending on time so that folks can move on to their evening obligations. So we'll try to clip through some questions if that we have in the Q&A box, and I will do that shortly. But I wanted to turn over to Professor Banner very briefly if you have any offhand thoughts or reactions to anything that was said by our commentators.
Only just to thank both of them for, I thought, really thoughtful, smart remarks. I don't really have anything say in particular, because my book is not a book about whether there is natural law or what it's like. It's a history book about how what lawyers think about the legal system has changed over time. I don't have a horse in the race about whether they were right or wrong. I'm just trying to understand how we got from a very different system 200 years ago to what we've got today.
Paraphrasing one of the questions here from one of our students who asked, are there any countries where natural law is more prevalent or still relevant? And I realize this goes outside maybe the four corners of your book, Professor Banner, but to what extent do you think this is a particularly American story, or maybe a more general story about legal systems in the modern world?
So the direct answer to the question is I don't know about whether there are other countries where natural law plays a large role. I think it is not just an American story. I think it. My guess is that you could tell a similar story about England and Europe, but I'm just guessing because I've not done the work to actually try to figure that out.
Another question posed by someone in the Q&A box is. It says, while slavery and women's issues like admission to the bar did appear in federal court, most litigation was and still is in state courts. Do you believe that another strong factor weakening the position of natural law was the elimination of religious qualifications for state office, which ended around 1840, so that no one could claim a common religious understanding for the people in any state?
Well, I don't know. I mean, I think the elimination of religious qualifications for public offices generally is another aspect of the kind of the separation of the domains of law and religion over the course of the 19th century. And there's a lot of other kind of developments you could point to. Honestly, it would be a factual question whether Americans grew more religiously diverse over the course of the 19th century. Probably they did. So maybe that played a role as well.
Mm-hmm. Another student question, this for Professor Dempsey in response to her comments on the book. Matthew asks, could Professor Dempsey give some examples of these possible permissible norms to help me understand how that suggestion would work?
So am I on? Okay. So yes. The basic idea is that we don't have to think of the positive law as being gappy. We could think of there being unarticulated, broad, abstract principles that are nonetheless engaged with by legal actors, relied upon by judges, and thus posited. They are source-based law. And so there's no gaps to be had. Now, what they specifically are, that's part of the nature of the proposition that's being offered here, is that they very well may be unarticulated, right? So for me to articulate all of them would sort of, perhaps they cannot all be articulated. But basically just think of a case where you think, oh, well, the positive law doesn't answer this question because there's no statute directly on point and there are cases that kind of lean in both directions. Nowadays, I think Professor Banner is quite right to say that 99 out of 100 lawyers are going to look at that kind of situation and say, oh, there's a gap. How shall we fill it? And then if judges get into the business of filling it through their reasoning, we say, oh, the judges are making up law. They're just going to extra legal sources to fill in the gaps of the law. So that's sort of the standard picture nowadays. But I'm saying that even on a positivist understanding of law, thinking of law as exclusively source-based, one could have a view of law that didn't include any gaps, because the norms that are available to you are broad, unarticulated, and many of them are permissive, which is to say you can rely on them or you could rely on another one. So this way of thinking about the law doesn't necessarily dictate that there's a single correct legal answer in every hard case, but it also is consistent with the idea that there are no gaps in the law. So the judges aren't running around making up law when they meet a gap, because we don't have to think of law as having gaps.
Great. Again, if anyone wants to get a question here under the wire, go ahead and put it in the Q&A box. A question here, has anyone evaluated the decline in natural law and its impact on the increase in rights for legal fictions like corporate forms and trusts, while limiting rights for human needs for clean air, water, and soil? Professor Banner, do you have any thoughts about that? Sorry, you're on mute. Go ahead.
Yeah, sorry about that. Yeah, so narrowly, I don't know. I don't think anyone has evaluated that. But let me say that a more broader point. One of the arguments of the book, which I did not mention, is that the change in thought about natural law, I do not think caused any change in the content of the law. That is, I think that the content of the law, what the law actually is, what the rules are, the content of the law obviously changed a lot during this period, but I think it would have changed just the same way, regardless of changes in whether you think that law is is natural or not. And so, I just about any sort of situation, you can resolve it those kind of the modern way, or you can resolve it the old way, and you can get to the same result either way. So my guess would be that, to answer that specific question, that the decline of natural law did not cause whatever, I can't even remember what I see, rights for corporations and so on. No, because you could have got there even if natural law had been retained as an acknowledged source of law. It could have been just the same.
So we'll conclude with, I'll kind of wrap up some question that I think Dick Helmholtz poses, along with a question from a retired philosopher here at Villanova. But before we do that, let me say the second CLE word. Thanks again to the wonders of technology, we're able to bring people from across the country. So our second CLE word in honor of our second commentator is Indiana. Our second CLE word is Indiana. Dick Helmholtz asked, how are we to understand the Universal Declaration of Human Rights? And Joe Betts asked about the Nuremberg War Trials. So I guess a kind of a question about, as it were, maybe post-World War II era resuscitation of natural law in the context of the UN Declaration and the Nuremberg War Trials invocation of natural law as a basis for law.
Yeah, I think that if you want to say, well, what's the most natural law-like part of our legal system today, I think international human rights would be it. And it was always the case, even during the heyday of natural law, it was always the case that even the heyday of natural law, it was always the case that international law was the field in which natural law played the biggest role because of the absence of positive law. There are no international statutes. And so there was much more room for natural law to play. When the legal profession stopped using natural law, it created something of a crisis for international lawyers. They said, well, wait a second, what do we have left if we're not gonna, do we even have a field anymore? And of course they do still have a field, and that's in part because they're, without saying as much, they're still using much of the method that of natural law.
All so very interesting, and we are at the end of our time, but lots more that could be said. And as others have recommended, it's worth going out and procuring your copy of The Decline of Natural Law: How American Lawyers Once Used Natural Law and Why They Stopped, Oxford University Press. Thank you to Professor Banner for writing the book and for presenting here to us. Thank you to Professor Dempsey and Professor Pojanowski for their commentating on it. Again, the CLE form is available in the email that you received, and there are links to it over in the chat box. If you have any questions, I will stay on for a bit with Melanie Dudley and Victoria Durand if anyone has any housekeeping on that front. But otherwise, thanks again to all of you for attending and participating in this webinar. And with that, we are adjourned. Have a good evening.